Hello, and thank you for joining us for Venable's CFPB debt collection rule takes effect November 30th. Is your team ready? I'm Jonathan Pompan, a partner at Venable here in Washington, D.C., along with my colleague, Alexandra McGarris in New York. And we're pleased that you could join us today for a session on the CFPB debt collection rule. Now, this session is actually part one of a two-part series. Next week, many of you and others have RSVP'd for part two. We will give additional information about part two later today, but for the purposes of today's session, we're going to be focusing exclusively on the debt collection rule overview and communications with debtors. Now, before we begin, a couple housekeeping items. This session is being recorded and will be available online as well as also on YouTube. So it'll be on the Venable.com website, as well as the YouTube site for the recording. And in addition, it'll be sent out to participants. Now, today's session also is not legal advice, of course, just educational for purposes, and any questions that you ask obviously would not be confidential under an attorney-client privilege. So with that, if you do have any questions of a general technical nature, please feel free to send them our way. But because the nature of this recording, we want it to be evergreen, anything very specific or particular, we might address offline, and we're happy to do that. Now, for anything that needs clarification, that perhaps got lost in translation, we're more than welcome to receive those during this session today and to address them as we go. Now, also, today's session will be for CLE, for those that are attending live in New York and California. It's been pre-approved for 1 credit. We're also going to be submitting this to the American Bankers Association certification program. So if anyone would like to contact us about that for a certificate or other info, please let us know. Now, today's session, as I mentioned, and as you know, is on the debt collection rule. And this purpose of today's session is exclusively to focus on the debt collection rule. Now, the debt collection rule is one that has been in the works for quite some time, and it's quite complex. Many of you probably have been studying it for the last year and perhaps living the ongoing drama of the ups and downs of what the rule may or may not comprise for essentially the last 10 years. Now, the rule is extremely technical, hundreds of pages of Federal Register notice and 10 years worth of backstory and 40 years worth of Fair Debt Collection Practices Act, statutory case law, and also interpretations from the FTC, and then later guidance and enforcement work from the CFPB. But today's session isn't intended to focus on the full totality of the debt collection legal and regulatory landscape, but rather to focus specifically on the debt collection rule. And because of the nature of the debt collection rule and how technical it is, we wanted to keep today's session at essentially sort of the briefing level, checklist type level, things to keep in mind, help reorient you to the extent that perhaps it's now back on your radar. And then otherwise, if there would be a need for a more in-depth detail or specific compliance work, we can certainly help as well as others. But this session is going to try to keep it at a level sort of at that briefing type level. Now, the content here, of course, is also not necessarily reflective of all of the available guidance on the debt collection rule. The CFPB itself has put out a small entity business guidance document, FAQs, and other materials to help organizations, both first-party creditors as well as debt collectors, to both understand the rule and compliance aids. Those compliance aids are terrific, and they're first-party sourced from the CFPB. And of course, there's no shortage of materials on the rule. And then there's the rule itself. And that's where usually everyone would start for clarification, including the past announcements about the proposed rule, which might help shed some more light. Now, where possible, we'll reference that. Now, the debt collection rule today, in today's presentation, is going to focus on communications. But before we do that, we thought it would be helpful to help reorient everyone as to what the debt collection rule is and the context for it. So the debt collection rule, of course, comes from and exclusively comes from the CFPB's ability to write rules related to the Fair Debt Collection Practices Act, which passed and took effect in late 1970s and 1977. Now, the rule itself, of course, goes into great depth, but the Fair Debt Collection Practices Act, which applies to third-party debt collectors and some debt buyers, is a statute itself that is actually quite intricate and has a lot of interpretation around it. Now, of course, in the most general sense, the FDCPA is intended to eliminate debt collectors' abusive debt collection practices, to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged, and to promote consistent action to protect consumers against debt collection abuses. Now, in 2010, the Dodd-Frank Act passed, and the Consumer Financial Protection Act empowered the CFPB to write rules around the FDCPA. Now, the FDCPA, prior to that and continuing even now, has the ability to be enforced and interpreted both by the CFPB and the FTC. Prior FTC guidance and procedures implementing the FDCPA were transferred to the CFPB, and those procedures are in what is called Regulation F. Now, up until now, Regulation F was frankly rather sparse. There weren't substantive requirements in there, and for the most part, it was procedural around the guidance that the FTC had issued in the past. But since then, and with the rulemaking, a lot has been codified in Regulation F. So not only do we have new substantive rules that we're going to be discussing today around communication and then other topics on part 2 of this webinar, but Regulation F itself now is essentially a full compendium of the interpretations and implementation of the FDCPA. That's important because as a resource, now Regulation F exists as sort of a one-stop shop. Now, in 2011, the Bureau reissued the FTC's guidance, and then also around that time announced it was going to initiate a rulemaking. But now what has taken place since then is, after 9 years, you now have the FDCPA's interpretation for purposes of select areas now announced by the CFPB and slated to take effect. Now, all of this, of course, is within the overall debt collection legal and regulatory landscape. That landscape is one that has been ripe with enforcement matters and private lawsuits going back to the 1980s. Now, just even recently, the CFPB has had no shortage of enforcement activity, and same with, for instance, the FTC. Now, even last year, debt collectors received, just in a generic sense, first party and third party collectors, over 82,000 complaints to the CFPB. There were 4 major enforcement actions brought in 2020 by the CFPB, including also a enforcement matter related to a prior investigation and enforcement action against a large debt buyer. Now, there's also been other activity too, related to debt relief services and debt collectors and various reports and guidance that the CFPB has issued, and they had done that for the last decade. Now, in addition, the FTC remains very active with over 7 different debt collection cases in 2020 with over 39 different defendants, and a notable case against organization for quote unquote debt parking. Now, all that is to say that the agencies have had a very robust enforcement docket and investigations, regardless of this new rule. The new rule just now adds additional layers of complexity and potential areas for future enforcement. Now, Should be noted too, CFPB resumed regular debt collector examinations in spring of 2021, and for the most part, seems to be fully up and running with respect to the examination and supervision activity. Now, to give some context to the debt collection rule, I think it's important to know that starting in 2013, there was a set of meetings and various proposals with respect to writing rules for debt collection. You may have heard and may have participated in some of those. They varied from proposals to regulate and describe and restrict practices for first-party creditors, to use UDAP authority under the Consumer Financial Protection Act, and then also third-party creditors. There were a variety of different proposals and meetings and a variety of different advocacy. Now, eventually, though, that brings us to 2019, where the CFPB issued a notice of proposed rulemaking to amend what was then Regulation F and implement substantive requirements and prohibitions regarding debt collection focused on third-party collectors. And then in 2020, the Bureau issued a supplemental notice of proposed rulemaking addressing time-barred debt disclosures. All of that came to a head in October of last year when the Bureau issued a final rule amending Regulation F to implement most of the FDCPA's substantive provisions. That's essentially cataloging the FDCPA and its various pieces, as well as addressing, among other things, communications in connection with debt collection, prohibitions on harassment or abuse, false or misleading representations, and unfair practices in debt collection. And then in December of last year, second part of the final rule was released, addressing and clarifying consumer disclosure requirements, required actions prior to furnishing, and prohibitions regarding the collection of time-barred debt, which to some extent ultimately was put on hold. But all of that will be discussed in part 2 of our webinar series. But although for purposes of today's session and next week's session, we're going to be referring to this as the debt collection rule or debt collection final rule, we're not necessarily going to distinguish between October and December. It's just important to note that most of what we're discussing today in today's session around communication is going to be in reference to the October issuance. But all of it is referred to colloquially by the Bureau and in various other guidance as the debt collection rule. Now, it takes effect on November 30th of this year. Earlier this year, there were proposals and a request for comments from the CFPB to possibly extend the effective date, including splitting the effective date for different pieces of the rule. None of that came to fruition, and so the effective date is November 30th. Why is that important? It's important because there are some requirements in the rule. There also are many opportunities, and most of the communication aspects of the rule relate to opportunities, both for third-party creditors as well as also for first-party issuers and prior owners of debts and accounts to optimize the potential for collections by the third-party creditors. There's also additional requirements around vendor management, and by implication, because there are new requirements here and restrictions in the debt collection rule for third-party collectors, first-party creditors, and anyone employing a debt collector has to have their eyes and ears on this, because there are now new requirements that ultimately could get the first-party creditor in trouble if the third-party collector is not in compliance. So with that, we'll transition to now talking about some of the basics of the rule, just to level set. Now, the coverage of the rule is debt collectors, and it's defined as it is in the FDCPA, subject to certain exceptions. That's any person who uses any instrumentality of interstate commerce or mail in any business, and the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be owed to another. That is right from the FDCPA, and it's important to note because as a result of all of this, the coverage would not alter the coverage of the FDCPA or suggest any new interpretation that the FDCPA applies to first-party debt collectors that are not debt collectors under the FDCPA. Now, also, the CFPB expressly declined to expand the scope of the rule, even using its UDAP authority, to first-party collectors. That said, first-party collectors should be alert for the potential for the CFPB to utilize concepts and other aspects of the debt collection rule, essentially in UDAP-related examination review of organizations that fall under its supervisory authority, as well as also in investigations and enforcement action. Now, the CFPB debt collection rule is not a perfect fit for the operations of first-party collectors. So first-party collectors will have to think about how and what may be relevant and material to their organization and risk tolerance. But as well known, we do know that the CFPB is looking to be extremely aggressive on all fronts, including with respect to debt collection generally. And so despite the forbearance of extending this rule to first-party collectors, again, we think first-party creditors and collectors should be alert. Now, the debt collection rule itself also has aspects of other definitions and coverage. As we'll go, we will mention many of them throughout today's session.
Thanks, Jonathan. So, as Jonathan mentioned, we will be focused on the communications related provisions of the debt collection rule today. So let's start with the definition of communication. The rule defines communication or communicate to mean conveying information regarding a debt through any medium. And so this has been updated for purposes of kind of accounting for new technologies. And so the Bureau has clarified that a communication can occur through any medium, including electronic, so long as it's conveying information about the debt, and that would cover communications with third parties, not just the debtor. In an acknowledgement that with online advertising, behavioral advertising and targeting ads online that are not specific to individual consumers, the Bureau has also said that marketing or advertising that does not contain information about a debt is not considered a communication under the rule. And then, of course, just like the FDCPA has been interpreted over the decades it's been around, an attempt to communicate is an act to initiate a communication through any medium, even if you're unable to actually connect with the person you're trying to get in touch with. A new defined term has been introduced as a result of this rule, the limited content message. So first, what is a limited content message? It's a very specific term. It is designed to assist debt collectors to comply with the FDCPA's somewhat conflicting provision. So first, it only pertains to voicemail messages left for the debtor. So it does not include other electronic communications. And that voicemail message that's left has to include these very specific pieces of content. First, a business name that does not indicate that the caller is in the debt collection business. And so if your company has collection or debt in its business name, leaving that name in the message will not qualify it as a limited content message. But you have to include a business name for it to be a limited content message. You can use a DBA that doesn't indicate that the caller is in the collection business. Second, it has to request that the consumer reply. It has to identify the name of one or more natural persons with whom the consumer can get back in touch with. And then finally, it must contain a telephone number. To qualify as a limited content message, it can include, doesn't have to, but it can include a salutation, the date and time of a message, suggested times to call back, and a statement that if the consumer replies, he or she can speak to anyone at the company, but it cannot include any other content. So to take advantage of this new term, the voicemail needs to have these very specific, meet these very specific criteria. And so why? Why does this matter? So first, the good news is that if you leave this type of voice message that perfectly complies with the definition, the voicemail itself will not be considered a communication. And therefore, you don't have to worry about potentially violating a separate provision of the FDCPA that requires you in a communication to meaningfully disclose the caller's identity. And so the kind of catch-22 that debt collectors were finding themselves in with voicemail has, at least in the CFPB's mind, been resolved by this statutory creation of the limited content message. That said, they are still considered attempts to communicate, and so they are subject to the time and place restrictions and the frequency limitations that we're going to spend a lot of today discussing. And so it's important to keep in mind that if you're leaving these type of voicemails, they will be considered attempts to communicate. The communication provisions of the rule cover a few different areas, one of which is the time and place restrictions on when you can communicate with not just the debtor, but any person. There was an attempt in the rule to flesh out what it means to contact someone at an inconvenient or unusual time, which is prohibited under the FDCPA. The rule has set that it's presumptively inconvenient to contact or to call someone before 8 a.m. and after 9 p.m. at the consumer's location. That in and of itself is not particularly profound, but the Bureau has clarified that there has to be an attempt to determine what time it is at the consumer's location, which has become increasingly complicated since the 1970s, when everyone had just one landline. And so the rule says that while a debt collector doesn't have to know where the consumer actually is at the time that you're trying to call them, you do have to take into account what information you know about that consumer. So if you have conflicting information about where a consumer potentially is, for example, the zip code suggests he's in one time zone and the area code of the phone number suggests he could be in a different one, you can only contact that person at a time that would be convenient in both locations, right? So if the area code says the person's from Virginia, the address suggests they're from California, you should assume that person's always both in Virginia and California at the same time. And that means you can't call before 11 a.m. Eastern time, which is 8 a.m. Pacific time, and you can't call after 9 p.m. Eastern time, which is only 6 p.m. Pacific time. Now, if you actually know where the consumer is because you've spoken to that person and they've given you consent to call outside of the time windows that are set out in the as a framework, then you can contact that person. So there is kind of an exception for where you have consent. With respect to what's an unusual or inconvenient place, the Bureau has said that, place of employment is presumptively inconvenient if a debt collector knows or has reason to know that the employer prohibits consumers from receiving, personal communications. That's always been the rule. The clarification is that you as a debt collector are not required to track like which employers prohibit personal communications. But the way that I've been advising clients is that unless you have consent from a consumer to contact them at the workplace, you should assume that they're not permitted to receive those types of phone calls. There's also the increased risk of third-party disclosure, which separately violates the FDCPA when you contact people at work. And so, although there's not a bright line rule about contacting folks at workplace, you should try to get consent to do so to prevent any potential issue with respect to, it being alleged that you should have known it wouldn't be convenient for that person to receive calls. And then finally, if a consumer, well, actually not finally, as I mentioned earlier, that there are exceptions to both of these inconvenient time and inconvenient place presumptions if you have that consumer's direct prior consent. Direct means that it was given to your company, not other debt collector that was previously servicing the debt, or not the creditor. It has to come from the consumer to your company. And it has to be prior, meaning prior to the call that is impermissible. So you can't call someone at 7 a.m. and say, is now a good time? And the person says yes. That is not prior consent. If you speak to them and say, is it okay if I call you tomorrow at 7 a.m. and they consent, that would be direct prior consent to contact them at a presumptively inconvenient time. And so finally, in addition to those kind of the presumptive inconveniences that the rule sets, if a consumer tells you some place or some time is inconvenient for them, then you officially know it is, and you can't contact them at that time or at that location. The word inconvenient is not a magic word. The consumer does not need to invoke it in order for them to be telling you that. This is a really difficult, in my view, kind of area for implementing on a large scale, because the rule essentially says that it's like a fact and circumstances, depending on the language the consumer uses, you may or may not, be on notice that something's inconvenient. So the rule does clarify that it's permissible to ask follow-up questions if it's not clear whether the consumer is telling you or one of your employees that it's inconvenient to be contacted at a place or location. And so for implementation purposes, what I recommend is having kind of a default requirement that if there's any indication that the consumer doesn't want to be contacted at a phone number or at a time of day, is to ask a clarifying question, because otherwise it just becomes too ripe for a he said, she said in a potential FDCPA suit. There is an exception for when the consumer contacts you at a time that person had previously said was inconvenient for her. So if you have a consumer that tells you, don't contact me, between 2 and 3 p.m., that's when my child sleeps, but she calls you between that 2 and 3 p.m. hour, you can then contact her at that time for 7 days, but only for that amount of time. And with that, we will talk a little bit more about electronic communications, which I mentioned the Bureau specifically said was covered by the term communication, and then included a lot of detail about the rules of the road with respect to how to communicate with consumers electronically in compliance with the FDCPA. And I'll turn it back to Jonathan.
Thanks, Alex. First and foremost, with respect to electronic communication, an important background note. While for a long time, various organizations and consumer groups, or perhaps lawmakers and policymakers, and even in some cases, due to risk decisions, organizations thought electronic communication, in particular, email communication, and then other forms of electronic communication as technology evolved, would either be prohibited or extremely complicated in a debt collection scenario. The reality is that electronic communication has always been legal under the FDCPA. There were no restrictions on electronic communication, but there were plenty of requirements and restrictions under the FDCPA that for many made electronic communication difficult or perhaps unwise. Some of that may have been technical limitations on the part of a collector, or data issues from with respect to data flowing from the original owner and creator of the account on the lender side to a collector, and any number of other reasons, including, of course, even adoption of electronic communication by consumers early on. Now, that being said, we all know that particularly mobile, and certainly just electronic communication generally, is by far becoming the predominant form of communication in general amongst consumers, and also with their financial institutions. So as a result, a big area of focus during all of the various aspects of that 10-year rulemaking that came to fruition with this debt collection rule, the constant has always been that electronic communication had been in scope, and the debt collection rule itself does address electronic communication in great detail. Now, but to recap, what were some of those limitations with respect to electronic communication and limitations that still exist? Well, that's the restriction on inconvenient times and place that we've just discussed. Also, the restriction and prohibition on harassment or intimidation through communication methods, communications, or through content or substantive aspects of the communication. The risk of a third-party disclosure, which is restricted under the Fair Debt Collection Practices Act, and the restrictions on no postcards or debts published in the classifieds and media, et cetera. No splashing of one's personal consumers' information and the existence of a debt, for instance, all over social media. But with all that in mind, there are now modern forms of communication methods that have some guardrails as a result of the debt collection rule. Now, the debt collection rule does not prescribe very specific ways one has to engage with electronic communication. There are no per se restrictions on electronic communication, but under the FDCPA, in light of the bona fide error defense, there is now guardrails for those who choose to use them for potentially putting one in contention for bona fide error defense eligibility. Now, we say that with air quotes and asterisk because bona fide error defense eligibility also rests on having policies and procedures intended to comply, very good record keeping of having complied, and then also assorted other interpretations, and perhaps now the goodwill of the Consumer Financial Protection Bureau, enforcement, or examination staff who may be tasked with interpreting all of this and applying it to a particular situation. But with all that being said, the communication provisions of the debt collection rule outline several different methods that one can use and take advantage of bona fide error defense for electronic email, as well as also text messages. Now, all of this, though, has one constant thread. We'll get into some of the details around email communication and text messages in a moment, but the debt collection rule has one constant for all of it, which is that the debt collection rule requires a debt collector to include a clear and conspicuous opt-out notice in electronic communications and electronic attempts to communicate with the consumer in connection with the collection of a debt. The opt-out notice requirement applies if the electronic communication or attempt to communicate is sent by email, text message, or by any other medium that uses specific electronic addresses. Now, for purposes of this opt-out notice requirement, the broader definition of consumer applies, so the opt-out notice has to be included in electronic communications and those attempts to communicate sent to natural persons who are obligated or allegedly obligated to pay the debt. That could also include others. So communications sent to a natural person's spouse, parent, if the person's a minor, legal guardian, and confirmed successor in interest. And as a result, blanket opt-out sort of inserts from a compliance standpoint operationally need to be used as a practical matter. Now, the debt collection rule goes into great detail as to what is a sufficient, clear and conspicuous notice for opt-out. And at its crux, it has to be a reasonable and simple method to opt out. So the opt-out notice must describe a reasonable and simple method by which the consumer can opt out of further electronic communications or attempts to communicate by the debt collector in that to a specific email address or in a specific telephone number for text messages or some other electronic medium which addresses the communication. So what that as a practical matter means is the ability, for instance, for text messaging to use the word stop or to unsubscribe, the opt-out notice using a hyperlink at the bottom of an email. None of this, of course, can be for an exchange for a fee. And there's also two important notes around this. One is that the literal language from a consumer is not the relevant standard. So if they say, stop emailing me, and you interpret that as just applying to a general advertisement, but not to a debt collection notice that was made and that attempt to communicate a debt, that's not how the Bureau would interpret it. Rather, they would want an organization to loosely interpret the consumer's language in their favor. Consumer may not know what language to use to ask to stop that electronic communication, may not actually be that specific. And also, too, there's no specific period for processing an opt-out request, but a organization has to have reasonable procedures to implement them in order to avoid liability. If those procedures are not evident and there's not sufficient record keeping around that, then there can be an issue with respect to how the opt-out is implemented. Now, for email communication, there is also a number of various requirements and guardrails for taking advantage of the bona fide error defense. And so unless one or more of the variety of exceptions apply, the debt collector must not communicate with in connection with the collection of any debt to the consumer's attorney, consumer reporting agency, et cetera. But the communication can be done otherwise. And so electronic communication's always been viable. Now you have these new guardrails. Now, so to start off, the most important thing here is you have the ability to have a bona fide error defense for emails based on the communication between the consumer and the debt collector. And I think that, you know, in terms of all the relevant detail, certainly the slide that you're viewing now has quite a bit on here. But just to recap, The debt collection rule describes 3 separate procedures that a debt collector can adopt and follow in order to obtain that bona fide error defense when sending an email message. We'll describe each one just in general. So as a threshold matter, email procedures based on communications between the consumer and the debt collector comprise several different requirements to take advantage of that bona fide error defense. The debt collector can utilize an address that was used by the consumer. If the consumer is sending the email message to an email address that the consumer has used to communicate with the debt collector about the debt, and the consumer has not since opted out, direct prior consent would be also viable. The debt collector has received direct prior consent from the consumer to use that address in connection with the collection of the debt and hasn't withdrawn it previously. So if you're maintaining and adopting procedures around record keeping and the opt-out, adding a clear and conspicuous notice to any website or portal or other place where one might collect the relevant email address would be optimal. That notice would then let the consumer know that if the consumer provides an email address, the debt collector may treat that email as one they can use for electronic communication, of course, with the caveat that the consumer can always withdraw that. Now, in addition to that, you'd want to also have very robust procedures to reasonably confirm and document that the debt collector did not communicate with the consumer by sending an email to a third party. That's a constant thread for all 3 possible guardrails for bona fide error defense with respect to email communication. And an important one, that means tracking of inbound requests as well as misfires of email and other data collection and then analysis to cull through email addresses before they're being used to reasonably avoid using ones that wouldn't work. Now, you can also have the ability to use ones where you have email based on communication by the creditor. Now, this is the second form of email communication guardrails. So the creditor in this case can obtain the email address from the consumer, but that can't be if the email address came from somebody else, including a skip tracing service. It has to be from the creditor. And the term creditor means any person who offers or extends credit, creating the debt, or to whom the debt is owed. Then second prong here would be that the creditor used the email address in communicating with the consumer about the account underlying the debt, and the consumer did not ask the creditor to stop using it. That's billing statements and disclosures, periodic statements and invoices, other things related to the actual account. But importantly, that's not email addresses used for general advertising and marketing purposes, promotions, cross promotions, and the like. So have to be careful in that regard. And this is where the creditor can play a real major role in developing robust information and data that can later then be used in the collection effort, whether by themselves or by a third party. Now, before the debt collector used the email address to communicate with the consumer about the debt, the creditors had to have sent the consumer a written or electronic notice to that address, and several factors have to be part of that, including a notice to consumers that clearly and conspicuously discloses that the debt has or will be transferred to a debt collector, that the email address may be used to collect the debt, if others have access to the email, that the email might be seen, and instructions for opt-out. Now, you also have to include a date as to when that might happen, and it has to be at least 35 days after that notice is sent. Now, the Bureau has prescribed what that notice could look like, and as a practical matter, collectors seeking to rely upon the information given to them by the creditor would want to be able to know that what that notice looked like and how the notice was effectuated to some extent. And so as a result, there is a standard notice that could be used. It's not required. Other forms could be possible. We provide that in the following slide, but also there is one for notices related to written and email. Doesn't have to be an email notice for use of the email address. There could be written notice. So there is some flexibility here, but there's a lot that a creditor would have to do on their end, and then a lot that a collector would have to do to understand what the basis is. Now, of course, you want the reasonable procedures in place related to the potential third-party misfires related to an email address. So that way it's the bona fide error defense can be taken advantage of. Now, there's also, lastly, email procedures based on communication by a prior debt collector. And that's significant because that sort of ropes in some of these prior items related to use of email address. So if the email address is collected in accordance with the procedures that we've just discussed, then the prior debt collector can have adopted such procedures to obtain that email address and follow procedures when using the email address. They also would have to have, prior to the debt collector using the email address to communicate with the consumer about the debt, the debt collector would have to have been prior to that. So there's examples given. We give one here on the screen. There's some others from the CFPB and in the rule and some of the guidance. And of course, the consumer may not have opted out. If they did, then of course, the use of that address is off limits. Now, text messages, little different. There's two sets of procedures that debt collector can adopt and follow to obtain that bona fide error defense eligibility when sending a text message. Debt collector could adopt either or both of the procedures depending on whether the consumer has communicated with the debt collector by text message or whether the consumer has directly consented to the debt collector sending communication by text messages. Now, regardless of which set of procedures is used, of course, the collector has to adopt procedures for text messages to reasonably confirm and document that they did not communicate with the consumer by sending a text message to a telephone number that the debt collector knows has led to a violation of the prohibition on that third-party communication. Again, reason we're emphasizing this is going to be one where we know will be very much in scope and scrutinized in examinations and any potential investigations. And so one of these two options does need to be followed.
Given the time, first I wanted to give the CLE code, which will be the word November 30, so November 30, and then cover the call frequency requirements under the rule. The rule has attempted to provide some bright line rules to help debt collectors comply with the FDCPA prohibition against repeatedly and continuously calling a consumer with the intent to harass, abuse, or oppress that person. The rule sets a presumption of violation or a presumption of compliance, which can be rebutted. The rule itself says that a debt collector is presumed to violate the statute if it places a call to a person more than 7 times within a 7-day period or within 7 days after engaging in a phone conversation. And the inverse is true. If you don't exceed either of these, you're presumed to be in compliance. And we'll talk about some of the calls that don't count towards the 777 rule. This prohibition is only on calls, phone calls. The Bureau has clarified that a ringless voicemail, meaning when you are able to go straight to voicemail and not have the phone actually ring, that's still considered placing a phone call and counts towards the 7-7 clock. Text messages and emails do not count towards the phone frequency limits here. And then importantly, when does the 7-day clock start running? it's the date of the phone conversation. And we'll get to some examples to illustrate the rule. And so let's say on Wednesday, December 1st, ABC attempts to communicate with the consumer and leaves a limited content message between Thursday the 2nd and the following Tuesday the 7th. ABC places 6 more phone calls to the consumer, all of which go unanswered. This call is presumptively, this pattern of calls is presumptively compliant because there are 7 calls being made in that 7-day period. Another example, if on December 2nd, a consumer calls the debt collector and there is a phone conversation between a debt collection employee and the consumer, that debt collector is unable to contact that consumer again for 7 days. So even though it was the consumer that initiated the phone call, because there was a phone conversation, you have to wait 7 days in order to engage with that person again. On the other hand, in this example, we have presumptively non-compliant conduct. So Wednesday, December 1st, ABC attempts to communicate with the consumer and leaves a limited content message. So that message is not considered a communication, but it is considered an attempt to communicate and counts towards the 7 rule. On each of the next 3 days, so Thursday, Friday, and Monday, ABC places 2 additional calls. Also, they go unanswered. And then on Tuesday the 7th, an additional call is placed. We've hit, did I do this math right? If it's 2 calls each of those days, we've exceeded the 7 limits in the 7 days. Sorry about that. I thought I got my math wrong. Importantly, this rule applies to per person per debt. This was something that the Bureau debated. They thought about maybe doing it per person, but ultimately it's per debt. There is an exception for student loan debt if various debts are aggregated under a single account when the debt collector receives the debts. That's considered a single debt, and you can't kind of call 7 times within 7 days for each of those accounts. But otherwise, if, for example, you're collecting a credit card debt and a medical debt owed by the same person, you have more leeway to contact that person, although it gets complicated. And so in this example, if ABC attempts to contact someone that owes 3 different debts that they happen to be collecting, and places a call, wants to discuss all 3 holistically, but the call goes to voicemail, and they leave a voice message that just discusses and doesn't discuss any of the debts in particular, just says, call me back. For purposes of this provision of the rule, the call frequency provisions, ABC can assume, making a decision about which of those debts that call was about. And as a result, it can make, let's say it chooses the credit card debt. It can make 6 more calls in 7 days about the credit card debt. It still can make an additional 7 calls about the medical debt and an additional 7 calls about the mortgage debt in this hypothetical. That said, if one of these calls are successful and you do have engagement with the consumer, then you can't place additional calls for 7 days in order to meet that second prong of the rule. Some calls don't count towards the counting, and those are calls placed with their direct prior consent. We previously discussed what that means. This only lasts for 7 days. I think I misspoke earlier and said it applied for the inconvenient times, but it's actually for the call frequency. Calls that do not connect don't count. Busy signal, for example. That said, calls that connect and then drop do count. So your IT departments that handle the dialing really need to be pulled into these conversations about an implementation to be compliant, because there's a lot of technicality to these rules. And so presumably you're not, for folks that are not manually counting how many times they're contacting consumers, but rather are working on with systems that count for them. You need to keep in mind some of these exclusions are difficult to code into your system, and there are ways to get more kind of abilities to call more often if you're able to implement these exclusions, but they have to be done very carefully. And then finally, calls about a debt that are placed with the attorney of the consumer or the creditor or credit bureaus don't count. And so just as a recap, you still could violate the debt collection rule in the FDCPA if the natural consequence of another aspect of your telephone calls, like unrelated to frequency, has the natural consequence of harassing, oppressing, or abusing any person. So you still have to keep all of those rules that you took into consideration when thinking about the FDCPA section on harassment. They still apply. Also, state laws still apply. This federal rule does not preempt state law. So where there are state law requirements that are more onerous or more restrictive, you still need to comply with those. And then finally, I mentioned that this framework for the 777 rule sets up a rebuttable presumption. What does that mean? For today's purposes, for getting you ready for November 30th, not much. But what it does mean is if you do, meet the 777 rule, the CFPB still has the ability to say that, to show that you intended to harass somebody, and can, try to find evidence of intent, even if you comply with the rule, but also vice versa. And so if there is a technical violation where additional calls were made, there's a presumption of noncompliance, but you have the ability to present evidence, whether it's during an exam or an investigation or private litigation, to show evidence that that the 8th call, the 9th call, whatever it is, that it wasn't an intention to harass. And the rule itself lays out some non-exhaustive factors that can be taken into consideration in the event you find yourself in need to defend excessive calls, or in the inverse, if someone's trying to establish that you violated the rule even though you did comply with the 777 rule. And so that comes into play in litigation, and we'll see how that plays out once the rule goes into effect in 5 weeks. So with that, we've hit the end of our hour together. Join us next week. We can answer questions that we didn't get to about the communications provisions, but we'll also cover the rest of what the rule requires, including validation notices, disclosures, record keeping requirements, etc. And then for those interested in what the FTC's been up to, it's been really wild there. And so we are doing a webinar next week on some of the more innovative ways they're trying to get around the lack of authority under their 13B section of the FTC Act. And then we have another webinar in November, if you haven't had enough of us, that will be on CFPB investigations. So we thank you for your time. Please send us questions that you may have not been able to send by email, and we'll definitely get back to you.